Yes, Mr. Keith.
My lords, I'll return briefly to my to the first ground in relation to whether the appellant comes within the rules. As I said, the purpose of 276B and the 28-day window is to prevent errors, and to prevent an individual being suffering detriment because of a mistake or because of some other problem. And I will come to the discretion part of the 28-day rules. There is a discretion in the guidance that if an application is made outside of that 28-day rule, the Secretary of State, in exceptional circumstances, can exercise her discretion to allow that to count. As I said, the history of this provision is unfortunate. My Lord Justice Dingemans rightly pointed out that we submitted after Hock that there was a redraft of the rules coming. I'm instructed that is still in the process of being redrafted, but 2 years later it's not here. So I have to deal with what is before me. And Hock was the start of a clarification. The previous decision of the Court of Appeal in Massim Ahmed had taken a very hard line on appellants, and in Hock we conceded that the Massim Ahmed interpretation of 276B was far too harsh for appellants, and that there should be a much broader definition. But we didn't concede what my learned friend says we did, which is that any gap in residence could be disregarded by 276B. And as I said, the continued use of the word bookended comes from Hock, but the purpose of bookended in Hock was to distinguish, as far as I understood from the judgment, was to show that in Hock all of those appellants had open-ended leave and hence had no prospect whatsoever of falling within the 276B exception. And so, in my submission, the correct definition is not just bookended leave, but it's bookended leave that falls within the definition of 276B5. And that is where my learned friend and I disagree. He says all bookended leave is bookended leave, whatever the circumstances of the middle portion of overstaying. And the Secretary of State's submission is that it is vitally important what happens in that period of overstaying and what those applications are as to whether or not that can either count as part of lawful residence or be disregarded under 276B, and therefore any prior period of leave can be threaded together, disregarded in order to make up to the 10-year lawful residence. And in my submission, there is no need, as my learned friend says, to read into or rewrite 276B any further than was done in Hock. The difference between the application and an application, in my submission, makes no difference, because the whole purpose of 276B5 and the subsequent 39E rule was, as I've said, to prevent a short gap in overstaying from poisoning a 276B 10-year rule application at a later date.
All right. Well, so you've been very clear as to what you say the purpose is. How is that purpose given effect to in the language of the rule?
Well, probably easiest to go to that rule, my lord, rather than so. Bundle of authority, page 40. And as I said, it's 276B, little 5. And in this case, we're dealing with little 5, subsection A, because it's prior to the 24th of November 2016. That reads, the applicant must not be in the UK in breach of immigration laws, except that, where paragraph 39 uses of this rules apply, any current period of overstaying will be disregarded. Any previous, and then the section that applies to this case, any previous period of overstaying between periods of leave will also be disregarded where, and A, the previous application was made before 24th of November 2016 and within 28 days of the expiry of leave. That's the provision that applies to this case.
Okay. I don't think there's any dispute as to that, because it's not suggested that 39E applies. That's common ground, and so therefore the question is whether the appellant is within 5A.
Yes. So the appellant makes the application and it's refused. And in my submission, there is no basis for then saying, well, because you made an application which was refused and then stayed in the United Kingdom for an indeterminate, in this case it was only a month, but for an indeterminate period of time until you got further leave, means that that period of overstaying should be disregarded under 276B.
Well, the argument is that that's what it says. You don't need a basis for saying it, other than that's the wording, that's the natural meaning of the wording of 276B 5A.
With respect, my Lord, it must be. I don't know how it can be read like that, because if 276B goes to whether you have bookended leave that can be disregarded, and so the period that can be disregarded always starts from somewhere within that 28-day window. So the 28-day window allows you to make the application, and then that is extended by various until such stage as you get that application granted.
Well, what can you just take it in stages? So, what in your submission are the words "the previous application" referring to? I mean, I used the expression when I asked Mr. Jafferty the same question, antecedent. That may perhaps, on reflection, not be the right way of looking at it, but one is still left with the question of what is it that is being referred to when it says the previous application, because whether one expresses it in terms of an antecedent or not, it seems to be referring back to something. And what is it that it is referring back to?
Well, it can only, in my submission, it can only be one of two things. It can either be the first application, which would make no sense whatsoever, or the application made within the 28-day window. And in this case, there are only those two applications that we are considering in this particular part of the question.
Well, another way of looking at it is the previous application is linked to the periods of leave. In other words, the application previous to the second of the bookend.
Yes.
It's not because it's not a previous application, just any old previous application. It's one that is relevant to the two bookended periods of leave.
It's the one that allows the appellant to link the two periods of leave together. Because, my lords, this of course only arises in a scenario where an applicant has made an out-of-time application. So their 3C leave, or their leave to remain in the United Kingdom, has already expired. Then they make an out-of-time application. Because if that, and as I haven't made it clear, if the application made within that 28-day window had been successful, then we wouldn't be here. Because that would allow the appellant to thread together all of the material, and we would ignore that period between his leave, the disregard, in order to use the correct terminology, the period when his leave expired, and the period for when he was then granted new leave. And that period might be 1 day, might be 10 days, might be 6 months, because it might be that it takes a significant period of time. But for instance, in AFSAL was all about out-of-time applications and whether you could backdate them or not, and whether or not that then gave rise to lawful leave to remain or not, and then whether that counted. But in AFSAL, the applicant had those two periods of leave. But the issue.
All right. So can I put your submission, if I've understood it correctly, which I may not have done, into my own words, because that's a way of testing whether I've understood it. So, do I understand you to be saying that when we look at the language, what we are to understand is that we are concerned with a period of overstaying between periods of leave, and that's going to be disregarded if the application that is material was made before 24th November 2016 and within 28 days of the expiry of the first of those two periods of leave. So we have leave, gap, leave, and the question is whether the application that gave rise to the second period of leave was made within 28 days of the expiry of the first period of leave.
Yes. That's my submission. And I apologise, I haven't put it clearly.
Can I just ask you one point on that? I mean, I think you can take some support from any previous periods of overstay between periods of leave will be disregarded where, because that means that not all bookended leave falls to be disregarded. So that must follow from that. But if you're right that the previous application is the one that results in successful grant of leave, why doesn't it say the application? Why does it talk about the previous one?
I suspect, so I don't have, but this is my the logical conclusion, or may not be logical conclusion, is that the application is the application for 10 years lawful residence. So the application is the application that as an applicant have been here for 10 years and you should give me indefinite to remain. And therefore the previous application is the application prior to that application that grants you leave taking you up to that 10-year point.
Thank you. I understand.
I think
It doesn't quite work because couldn't you have more than one bookended period of leave?
Falls down, my lord.
Yeah, that's where it falls down.
You could have a significant number because you could get lots of 6-month periods, you could get 9-month periods. They could be strung together with. There could be 6-month periods strung together with periods of 3C leave in the middle of a year or 2 years.
Yeah.
But ultimately.
It doesn't mean the one and only previous application, the previous application that you are considering, I suppose it could be. We're adding quite a lot of words here.
What? It's the previous application that relates to the period you want to disregard.
Yes.
It has to, otherwise the whole thing falls down. And so this appellant's issue is that period at the end when he doesn't have any extant application.
Yeah, but that's, as I understand it, that's a separate point. Because if I've understood you correctly, what you're saying is that looking at the facts of the present case, if you're right as to the interpretation of 276B5A that you've just put forward, then that leads to the conclusion that if the application that the appellant made on the 2nd of September 2014 had resulted in leave being granted, then that would have enabled that period of overstaying to be disregarded because that application was made prior to 24th November 2016 and within 28 days of the expiry of leave on the 9th of August 2014. And your first submission is, well, on what you say is the true construction of subparagraph 5A, it doesn't work because, in fact, the appellant was unsuccessful in that application. But then your second submission is, even if you disregard that, there's then still the period from the 30th of October to the 28th of November when there's no extant application at all. Moreover, he can't rely upon the temporary admission and consequential grant of leave thereafter, because that only takes him back to the date when temporary admission was granted. Have I understood you correctly?
Absolutely, my lord. I suspect my second argument was belt and braces rather than...
Yeah, to be sure.
And my lord, in my submission, that is... it's not simple, because this is my third trip to this court to discuss this provision.
Well, I think you and Mr. Jeffrey have kept the courts busy on this point. To be frank, because it isn't clear, until it is redrafted, we can expect a lot more litigation on this, and that does no one any good.
I will feed that back in any event.
Well, they know that. They were told that in Hague, and everyone understands the difficulties of trying to do these things.
My lord, that is my submission in relation to the rules.
Yep.
In relation to 276B. Unless I can further on.
Can I just ask you this? You did put in a respondent's notice in relation to your construction of the rules. Do you need a respondent's notice?
My lord, in my submission, not. I put in the respondent's notice, again, as belt and braces, and I did say that in my skeleton argument. My learned friend's original skeleton argument made the argument that Judge Gleeson had accepted that the period the period we're discussing was in fact intended overstaying within the meaning of 276B. I wasn't able to see that in my submission. That's not correct. But I suppose if you find that my learned friend is in fact correct about that, and Judge Gleeson was right about that, then I might have required a respondent's notice in order to change my position. And I also take on board my Lord Justice Dingemans' point that this shouldn't be a moving target, and also have to accept that the decision in this case is not accurate, as my learned friend has pointed out, in terms of its reference to 39E and 3C, and that there are a lot of mistakes going on, which is why myself and Mr. Jafferty are here again, trying to not make bad law on what's happened before. Most of that is not the appendix.
Yeah.
I accept that.
Okay, so as I understand it, you submit, first of all, you don't need a respondent's notice. Secondly, if you do need one, you did file one, and the appellant has been able to meet it. And on that view of the matter, the one thing you didn't do was pay the fee. So would you be able to offer an undertaking to pay the fee in the event that we conclude that a respondent's notice is required?
I'm sure I can, Arnold, but I need to turn my back.
Of course. Thank you.
So just before we leave this, can you identify the bit of Judge Gleeson's judgment which you say supports the bit, your construction that you've just advanced?
Not really. is the straight answer.
Well, to be fair, it was an extemporary judgment given on a renewed application for permission to appeal to apply for judicial review. So it's summary. And I mean, to be fair to both you and the judge, there is reference to AFSAL, and it is asserted that he doesn't come within the provisions. But that's all I've really been able to take from it.
Yes, and so the part that my learned friend and I disagree about is the final paragraph. Although there's two judgments, so I'll make sure I've got the right one. There's the notification, and there's the notice. Let's bring it up. Paragraph 9.
Yes.
I mean, the core factual matrix isn't the same as AFSAL. AFSAL was about out-of-time applications. It was about whether 3C leave was properly introduced. But again, to be fair to Judge Gleeson, the argument that was presented to was about AFSAL.
Yeah.
And the part that I think my learned friend rely on, and I also rely on, is the final part of paragraph 9, that requirements of paragraph 276b are not met, and paragraph 276b's little 5 does not avail it. So
Is it relevant in this context that what we are concerned with here is not a substantive appeal on a substantive judicial review application, but what we're concerned with is an appeal against a refusal of permission to apply for judicial review?
Yes, my lord. Although the way that we dealt with it in AFSAL was that the Court of Appeal in that case effectively gave what permission's already been granted and then decided the substantive judicial review as the Court of Appeal.
Because we can't remit a statutory a judicial review from UTAG back to UTAG, can we?
No, I don't think so.
No.
So this would be a determination on the facts of this case in a judicial review held before this court.
There are two issues: whether we grant permission to apply, and if so, what our answer is.
Yes, although I don't know the status of the. Yes, you would have to grant permission. You'd think that the judicial review is arguable.
Yeah.
And then decide the substantive merit, which is what we've argued before today.
But then, would I be right in thinking that being so, the point that you're now arguing comes in really on the substantive JR?
Yes, the point of argument comes in on the substantive JR because we have a full one-day hearing in which all the issues can be ventilated, in which we can both make full arguments.
Well, and there's no dispute as to the facts. The question then is a pure question of statutory interpretation as to how the rule applies on those undisputed facts.
Precisely.
So can I just clarify my understanding? You're first of all saying we shouldn't grant permission to apply because it's perfectly clear that whichever way you read 276b5, he doesn't qualify. But if it is arguable that he does, then grant permission, treat this as the hearing of the appeal, and for the reasons you've given, refuse the permission, dismiss the appeal, or refuse permission to apply for judicial review.
Or if you think that it is arguable, grant permission to apply for judicial review and then decide the substantive judicial review in my submission in favour of the Secretary of State.
Yeah.
I hasten to state anything in 276b as being obvious. there anything else I can assist your lordships on in relation to the rules part of this?
No, thank you.
My learned friend's second submission is in relation to discretion. It's my submission that there is no discretion inside the rules. So there are two parts to this.
Well, I haven't understood Mr. Jafferty to suggest that there is. As I've understood his argument, I'm speaking purely for myself, and I may have got the wrong end of the stick. His very point is that was how it was treated by the caseworker, and he says that's wrong. He says the whole point about the discretion is that it's a discretion to grant leave outside the rules, and that discretion, he says, has not been exercised.
In which case, I slightly misunderstood the point. So,
well, sorry, that's his. I may be jumping ahead. I mean, that's his second argument on discretion. I suppose what I've jumped over is his first argument on discretion, which is that the policy guidance point.
So my understanding is that the first submission on discretion is that there is a discretion contained within the policy guidance that allows the Secretary of State to look beyond 276B and grant it anywhere.
Yes.
And my submission is that doesn't exist.
Yeah.
And if I can take, I think the only real way to do this is to take you to the guidance. And again, I have to note that, of course, this hasn't been updated since AFSAR. Although, I think the out-of-time application guidance has been updated since AFSAR. That's not relevant to this particular section. So, in my submission, this is an application inside the rules on 276B. I accept that there is a discretion to grant indefinite leave to remain outside of the rules, as I said before lunch. But that discretion is exercised on an application for leave to remain outside the rules, not as part of an application for indefinite leave to remain inside the rules. So, if this appellant had made an application for leave to remain outside of the rules, or for indefinite leave to remain outside the rules, then that discretion could be exercised in this case. Whether or not it would be successful would be a matter for the decision maker. But this is not that application. This is an application inside the rules.
You said you were going to show us that on the application.
Well, what I was going to show you, my lord, is that there are some discretions in the policy document that my learned friend took to, and it leaves together his two submissions. The decision maker in my submission is clearly wrong about the discretion to grant. My learned friend says the discretion referred to in the decision letter is a discretion to grant leave outside the rules. In my submission, the discretion is not that discretion. It's the one referred to in the guidance at page 158 of the bundle, page 19 of the guidance, about out-of-time applications, and the discretion in cases...
I beg your pardon, could you give me the page again?
Page 158.
Thank you.
Headed out-of-time applications.
Yeah.
So this section is about the discretion, the bottom half of the page, starting when refusing an application on the grounds it was made by an applicant. deals with a discretion for those applications made out of time and allows the decision maker in exceptional circumstances to accept that application further outside the period than the 28 days prescribed. And in my submission, it may well be that the decision maker was referring to that part of the discretion when in the decision letter, but I also accept there are a number of errors in the decision letter, particularly the references to 39E and 3C leave are, as my own friends point out, incorrect. But in my submission, other than that discretion, there is no discretion given in the guidance or in the rules to grant indefinite leave to remain under the 10-year route.
So was this discretion addressed?
Well, this discretion isn't relevant for this case
Yeah.
because the appellant made an application within the 28-day period. But that is the reference to discretion in the guidance. My understanding, my own friend, is that...
Sorry, you just said that he made an application within the 28-day period.
Yes.
But I mean, the whole premise of your first submission on 256B5 was that it wasn't the application wasn't within the 28-day period.
No, my lord, sorry. In which case, no. So this appellant, his application is made on the 2nd of September.
Yeah.
So that was made within a 28-day window.
Yeah.
Yes.
2nd of September 2014.
Yes.
Yeah.
So that was within the 28-day window.
Yeah.
If, for instance, he made it on day 30,
Yeah.
let's say he'd been granted leave, in this case, but he'd made the application on day 30, it was open to the caseworker on provision of evidence of exceptional circumstances to say, I will extend that 28-day window to 30 days and then disregard that 30-day period.
But what about the second application that he made on the 28th of November?
He didn't.
He didn't.
30th of October, when he made the application, 21st.
His second application is made in February 2015. He's granted temporary admission in November 2014.
Yeah, and that was not as a result of any application.
That was not a result of any application. So I'm sorry if I may have slightly taken us out of turn, because the only reason I'm taking you to page 158 is to show you that that is where I say that there is a discretion in the Secretary of State within the rules, and that there aren't any other discretions in this particular, in 276B.
Yep.
So, but my understanding is that my learned friend then relies on the concession that was made in hoc, or alleged concession that was made in hoc.
Before that, he also relied on what he said was a discretion in page 155, which was the gaps in lawful residence.
The example gaps. So, I mean, perhaps it might be worth just working that through, my lord. So, example 1 is that an applicant has a single gap in their lawful residence due to submitting an application 17 days out of time. The question to the caseworker is, would you grant that application in this case? And the response is yes, grant the application, because the rules allow for the period of overstaying of 28 days or less when that period ends before the 24th of November 2016. So in example 1, somebody has made the relevant application within the 28-day window, and so the period of 17 days can be disregarded. No exercise of discretion.
Just an explanation of how the rules work, you say?
Yes. Example 2, The applicant has 3 gaps in lawful residence for 3 separate out times. They were 9 days, 17 days, and 24 days out of time. Again, would you grant the application in this case? The answer is yes, grant the application as the rules allow for periods of overstaying of 28 days or less when the period ends before 24th of November 2016. So again, this appellant has unfortunately made 3 out-of-time applications, each of which must have been successful, but because they were made within 28 days of his or her leave expiring, it qualifies within the rules. Example 3 is the applicant has a single gap in lawful residence due to submitting an application 34 days out of time. And here's the discretion. The applicant has provided a letter from their consultant stating they were hospitalised during this period. So this is the discretion. Would you be right to use discretion in this case? Answer, yes. And again, that's the guidance that I just showed you over the page at 158. And the guidance is that even though the application was more than 28 days out of time, the absence occurred before the 24th of November 2016, and the applicant has provided sufficient evidence to demonstrate that there were exceptional reasons for the late application has tried to maintain lawful residence throughout the rest of the 10-year period. You must confirm this with your senior executive officer, SEO, senior caseworker. So there, exercise of discretion, which is set out over the page for exceptional circumstances where an individual wasn't able to meet the 28-day period. Now that doesn't exist under 39E. That's been tightened, but because we're dealing with pre-24th of November 2016, that discretion is in place. And that is the sole example of a discretion being exercised, and that discretion is set out over the page. There is no other discretion available inside the rules application by submission.
I'm being a bit thick here. I thought the discretion that was being referred to in example 3, or illustrated in example 3, is the discretion referred to at the bottom of page 155, and that 158 deals with a late application for 10 years long residence. Same test, but different discretion.
Maybe I've confused the two, my lord. Yes, my lord. I'm sorry. You're right.
So this is where there's more than 28 days between the expiry of the previous leave and the application for 10 years.
Yes.
Long
Sorry.
residence.
155 is the. My mistake.
It's the
155 is the.
Is the discretion that allows you to waive, as it were, a bit of lateness on the grounds of illness or something else.
So the test in both cases is exceptional circumstances, and the examples of exceptional circumstances given are the same. It's just the context is slightly different.
Yeah.
So, and again, I'll be corrected if I'm wrong, but my understanding of the second discretion is that referred to is what is said to be a concession that again I made along with my leader in Hogg. And that is dealt with, hang on, dealt with AFSAL. Oh yes, sorry. So page 70 of the authorities bundle is AFSAL.
Yeah.
Paragraph 78 and which starts on page 70 and goes over the page 71. I'll give you a lordship a moment to read that. So in hoc and confirmed in AFSAL on specific instructions, it has been conceded that there are occasions when the Secretary of State's caseworkers have been more generous than they were required to be. But that is not the creation of a discretion or the creation of an additional power. And indeed, Sir Patrick Elias deals with that issue at paragraph 79, following the quotation from the skeleton argument, where he said, if that is so, in my judgment, it cannot constitute a public declaration from the Secretary of State. Second, it states that the practice is more generous than the laws require. This does not suggest that the immigration rules themselves are ambiguous, but the practice goes beyond what can properly require pursuant to the rules. The use of the word appear suggests there may be some doubt about how regular and widespread is the practice. Again, militating against it being a public declaration, adopting a particular construction of a genuinely ambiguous provision. I don't resile from that concession which I made, again, on instructions with my leader 2 years ago and was repeated in AFSAL. But in my submission, it still does not create a discretion for caseworkers to consider every 276B application as both inside and outside the rules at the same time.
Well, I understand that, but it's a basic principle of justice that you treat like cases alike and unlike cases unlike. And if there is in fact a practice of being more generous, or at least there has been such a practice in some cases, the appellants are entitled to ask, well, why don't I get the benefit of that?
Well, the answer is that the caseworkers in those cases made mistakes and gave people leave when they shouldn't have done. I don't know how many there were. And the Secretary of State, having discovered this some time on, having the law being clarified several times by this court, cannot legitimately go back to those individuals and say, well, we granted you 10 years ILR, and now 2 years later.
Yes, but I see the force of that submission, but then one has that. This is why one inquires into what the court was told previously, because I absolutely understand the submission that the fact that a particular applicant has previously wrongly been given leave to remain does not give rise to any legitimate expectation on the part of subsequent applicants. Absolutely understand that submission. But that would apply where the previous decisions were simple mistakes on the part of individual caseworkers which happened to benefit those particular applicants. It is different if there is a practice, because if there is a practice, then that's not a question of individual mistakes by caseworkers. It's something more consistent. And that is capable, surely, of giving rise to legitimate expectations.
We were very careful how far to take that concession. We conceded as far as we could do. I don't have specific...
Well, see, the question I see, particularly given the way that Sir Patrick Elias deals with the matter, one wonders if perhaps the word practice has been used in a way that creates the wrong impression. Because, as I understand what you're submitting to us this afternoon, what you and your learned leader were attempting to describe was the fact that there was evidence of occasions on which applicants have been mistakenly given the benefit of favourable decisions to which they were not entitled. You weren't, if I've understood you correctly, intending to accept that there was any kind of settled practice to that effect.
Precisely, my lord. What I was trying to avoid and might have failed was to say there was, for instance, a guidance document that nobody had seen, or a way of working that meant that this instance happened on a regular basis.
Yes.
But we couldn't. It would have been wrong for us to stand before the court and say there are no instances, having been informed that there had been some instances, there were no instances of this. I'd also have to go back. I accept that there are occasions where legitimate expectation might be raised, but I think I'd have to go to. I haven't got all the case law on that, but I think it's in fact in Akinola. We argued quite a lot about legitimate expectation in Akinola, and my submission that concession doesn't meet the test, although I think I might have to just go to precise.
Well, I would have thought the shorter point is that it's not a point on which there's any ground of appeal. I mean, the second ground of appeal is relies on the policy guidance. I see, per the concession made to the Court of Appeal. Okay. That's a rather confused version of things. It's either the policy guidance or it's the concession. I don't see how they can be
well, I mean, that's why I wanted to deal with. I think I've dealt with the policy as far as I can do, but I wanted to deal with the concession as well.
Sorry, just to ask a question. You've shown us the concession as it was recorded in AFSAL. That was recording the concession that was made in Hogg. Where in Hogg is the concession set out?
It is set out. It's in. I think it's in Lord. I know it's in Lord Justice Underhill's.
Yeah.
Let me just. If I can just find it for a moment. My Lord, so yeah, Mr. Justice, help me. Paragraph 38 of Lord Justice Underhill's judgment.
Which is a reference to the gaps in lawful residence. One.
Yes, and then he comes to at the end of it, after the bullet points.
Yes, but that's the policy guidance. The policy guidance, as we've just been debating, is one thing. The alleged concession in Hogg is another thing.
I think we made several concessions in Hogg on a different.
There's another concession recorded at 42, but that is in relation to Massim Ahmed and it being too strict, which, as you rightly pointed out, it was never the Secretary of State.
I mean, the I'm not sure it's recorded. I'm not sure whether 104 deals with it.
So paragraph 104.
Paragraph 104. Your Dutch, my lordship. The middle of the paragraph. Accord to the explanatory memo HC 667 reflects the Secretary of State practice when dealing with applications.
Yes.
So we are told on behalf of the Secretary of State. And it's more beneficial to applicants for definitely to remain than my provisional view. In the case of ambiguity in the rules, it is permissible to adopt an interpretation more generous to applicants on the basis of the Secretary of State's statements about how practice compare.
But Sir Patrick Elias sets out what counsel said.
Yes.
And I just wonder where that came from.
Well, my learned friend submitted my skeleton argument, my Dingemans' skeleton argument as evidence.
Right.
And so that's where he took that. I mean, if it assists, I can provide that. So I think it was 7 or 8 pages.
My lord, we have copies of the skeleton if it assists.
Yeah, no, I'm sure it's actually recorded. I was just wondering whether it was recorded from Hock or it came somewhere else. Yeah.
No, I don't think it was specifically, it wasn't really an issue in Hock again, my lord, because we were dealing with bookended or, well, we were dealing with 3 applicants who didn't have leave to remain at the time. So no,
Thank you very much.
I think possibly, my lord, because we were actually making a much bigger concession in that skeleton argument, which was that Massam Ahmed was wrongly decided.
Yes.
And so that was right with the Court of Appeals decision in that case rather than, I say, it's a side issue.
And indeed, the practice relied on in the paragraph that Sir Patrick Elias refers to is that pointed out in the guidance to caseworkers.
Yes.
Which brings us full circle back to where we were.
So, my lord, in relation to the discretion point, my submission is that there is no discretion in the guidance, and that secondly, there is no general discretion to consider within the rules application as an application for leave outside the rules. Which is an entirely discretionary power of the Home Secretary. I mean, there is guidance on what the Home Secretary and caseworkers take into account in relation to leave outside the rules, in the leave outside the rules guidance, which Bank will have to go to today. But that is a separate consideration and has a much broader discretion, political and factual discretion given to the Home Secretary on what they can do. But in this case, that discretion doesn't arise because this is an application within inside the rules, and this appellant does not, as I've already described, fall within the provisions of 276B.
So where have we got the application itself? Showing that it was just within the rules.
The application is page 41 of the supplemental bundle, I think.
Page 41 to 51 of the...
Yeah.
My lords, 39 to 38 is the cover letter.
You mean 39 to 40?
Yes, that's
Yeah, that's fine.
Yeah, I was looking in the application itself for any reference to the rules. There doesn't seem to be one, but there is one in paragraph 12 of the cover letter.
There isn't. I understand. I have to check my internal correctly. I think there's a different fee payable for a leave outside of application to a 276B, to a 10-year residence route. I don't want to make a bad point on that.
Well, it's characterised as set LR, yet the type of visa application on page 41, line 1, 2, 3, 4, 5, 6. And that seems to be the fee identified on page 50 under payment,
Yes.
whatever that means. Standard service option.
And what about page 49? Do you have any other reasons for wanting to stay in the UK? That's right. I have, and he's either right or wrong about this, 10 years continuous lawful residence. And then my other reasons are Article 8, right to respect for life, etc., etc.
Which he doesn't qualify at the time. It was 276 ADE. He doesn't qualify for that because it doesn't meet the requirements. So the Article 8 it doesn't assist. It's a different route, a different set of criteria which he doesn't qualify for under 276 ADE. So I don't.
Does the letter say that?
I don't know. But there's no application as far as I can see for a leave outside the rules. I'm just trying to find
And Mr. Jappaji pointed to the first letter by way of response, which did say, oh, yours is a very complicated application, which raises human rights issues, and now we can see why. We'll need to consider it. And he then says a new date.
I don't know. It's not considered. I don't think it. But that's not.
Sorry?
I didn't understand that to be a part of the judicial review. It wasn't part of the judicial review and wasn't part of the leave to appeal in this case. Was a discussion on whether it qualified under Article 8 or not.
Mr. Jappaji referred to the claim form, which says, albeit in bold terms, discretion. Which suggests it's at least engaged.
I would have to find the application. I accept that in the form he raises Article 8.
Yeah.
But Article 8 has nothing to do with 276B, 10 years lawful residence.
No, and indeed, I mean the letter, the document seems to be specifically saying, by the way, have you got anything else you want to say for getting leave?
And I don't know the position as to whether it wasn't considered. That should probably been part of the judicial review. Should have, if it was a genuine human rights application, there would have been an appeal to the First Tier Tribunal under Section 82 of the Immigration Act.
Yeah.
I apologise, but I don't really in a position to deal with why Article 8 wasn't considered.
I suppose all you. So where's the decision letter again? Sorry.
Last document in the court bundle. The last document in the court bundle.
Yeah, so there's no reference in that to Article 8. It's all about whether he qualifies for 10 years or not.
So this was a response, this letter of the Sunday the 13th of June, yeah? Is that right? I've got it on page 65.
Yeah. Yeah, sorry, that's good. So it's in reverse order. So that, as I understand it, yes, it's a response to the application.
Yeah, and the decision letter records that the appellant's human rights claim was accepted, and that's why he has, and still has, leave to remain to the end of this month, and goes on to say that the decision does not involve a refusal of his human rights claim, and hence there's no right of appeal against it. So it's all about whether he qualifies for 10 years long residency or not.
Sorry, I had missed that. So, yeah. Your Lordship's of course correct. So that explains that Article 8, sorry, was considered. That's why it's got the leave. And so, which is why we're left dealing with only the issue of 276B and not the Article 8 issue.
Yeah.
So you said it was permissible, effectively lawful, because we're only dealing with auditing the legality of the decision-making process, to leave that part unanswered because he already had a leave which is going to expire at the end of the month and will be the subject of further applications.
Yes, I mean, and one of the options on Article 8 is one of the options on Article 8 is to grant a shorter period of leave. And it's the same with indefinite leave to remain. The Secretary of State goes through the decision-making process, and if they decide that in fact shouldn't grant indefinite leave to remain, it's open to the Secretary of State to grant a period of limited leave to remain. And the same with Article 8.
Yeah. Okay.
I apologise for missing that section. My Lords, I think that's. I hope I've dealt with the discretion issue as far as I can do. Is there anything else I can assist with?
Well, just this. I mean, Mr. Chafferty hasn't really put it in these terms, but I mean, it is understandable but unimpressive that these factual errors are made about what leave is being asked for and what done, etc. One response when someone says quash the decision is to say, well, you know, they've obviously messed it up completely, quash it, and they can make a lawful decision second time round. I suppose you said that we would still need to decide the 276B5 point.
Yes, my Lord. The decision that my Lord pointed to, dealing with a number of errors of law, I accept has a number of errors of law, and if this court decided that they would quash that decision and require the Secretary of State to remake it, then I would have no opposition to that. But this court would still have to deal with the 276B issue, and in my submission, this applicant doesn't make it within that period.
And then, as a matter of discretion, there's no point in quashing a decision which will, when lawfully made and the errors are not contained, won't make any difference.
Yes.
Yeah. Okay.
And I should say, it's not the appellant's fault that many of these errors have been made.
And one final point, because inevitably issues of costs are always raised after the event in writing and no one can really deal with it. Given the sort of way in which the decision making has taken place in this and the sort of slightly moving feast on both sides, even if you won, would you accept that the Secretary of State's position has hardly been a model of the way in which to engage in public law litigation?
I'm not sure I'd accept that, my Lord. I would accept that there have been a number of errors made, particularly at the lower level and as the case has progressed in the description of the law. And I hope that we finally got to the right provision. And I also accept that many of those errors are not the appellant's fault.
But on the other hand, if I've understood you correctly, what you say is that the errors don't actually, in the final analysis, matter.
No.
Does that mean, sorry to prolong this, that you're inviting us to have regard to section 31, subsection 2a, where we must refuse to grant relief if it appears to us to be highly likely the outcome for the applicant would not have been substantially different?
Yes, ma'am.
This goes beyond mere discretion. If we're in that territory, then we mustn't grant relief as a matter. It's just a rule, if that applies. This is a completely open question. It's only just occurred to me.
Unfortunately, I no longer carry a copy of the white books.
Well, no, what it says is it's an application for judicial review, subsection 2a of subsection 31, the High Court, which for this purpose I think is us, but it may not be.
No, I'm sure it is.
A must refuse to grant relief on an application for judicial review, and B may not make an award under subsection 4, which is to do with damages, if it appears to the court to be highly likely that the outcome for the applicant would not have been substantially different if the conduct complained of had not occurred. And we can disregard that if we consider it's appropriate to do so for reasons of exceptional public interest, which I don't think. Well,
I might argue with self-public interest. I would say that there isn't.
But that's an obligation that we have if that subsection applies to this case.
Well, section 31 must apply to this case, seeing as a judicial review, effective judicial review conducted by this court. And my submissions have always been that, in spite of all the errors, once they're all corrected, you still end up at the same point, which is that this appellant does not qualify for 10 years lawful residence. And therefore, the purposes of quashing orders and making them be redone it makes no difference to the overall outcome of the case.
Yes.
But might I accept have an implication on costs? Unless I've got any further assistance, my lords.
No, thank you very much. Any reply, Mr. Jafferty?
My lord, yes. I'm just going to take some of the short points first, and then I'll come back to the policy guidance, which I think needs a little bit more thoughtful consideration. Lord, on the respondent's notice, if I could just, I'm not going to take my lords to the correspondence. The correspondence is in the bundle.
Yes, we've
What
seen.
my lords will see is that a respondent's notice was initially submitted. There were deficiencies in it. There was a correspondence with the Civil Appeals Office, including the requirement that an application for an extension of time be made, and then there was a decision by the Secretary of State not to file a respondent's notice. So it's not the case that there isn't a respondent's notice and the only deficiency is that a fee hasn't been paid. There's a decision, a conscious decision that's been made not to file one. There isn't an application for an extension of time. There are no reasons. I would have thought that there would need to be an application for relief from sanctions in addition to the payment of a fee. Those are obviously relevant matters that the court will take into account. In terms of the options available for this court on this appeal, I think the situation in this appeal is exactly the same as it was for the Court of Appeal in Hock and also in Afzal. They were all appeals against the refusal to grant permission to proceed with a judicial application. The procedure followed in Hock and Afzal was that permission was granted because the points were difficult and at the very least arguable, but then upon substantive consideration the court refused the application for judicial review. The appellant would have no objection to the court proceeding in the same manner.
And you say that at the very least the changing positions that we've had to deal with indicate some issue of arguability.
My lord, yes, and the interpretation of 276b5, even if my lords are against the appellant on that, it's at least arguable, it's not clear, and at least merits the grant of permission, and the discretion point as well. And I'll come back to the discretion point because I think there is some distance between the appellant and the respondent on discretion within the policy, and so the appellant doesn't accept that this is a case where there is no discretion and that therefore a reconsideration would be bound to fail, even if the appellant is wrong on the construction, and therefore this is not bookended within 276b5. The appellant says that there is discretion, wide discretion within the policy, and that therefore the lack of an exercise of discretion is material, and it cannot be said that it is very likely, or I think highly likely is the terminology in the Act, that the outcome would be the same. In terms of bookended overstaying, I just wanted to clarify that the appellant's position is exactly as my learned friend put the respondent's position. Bookended overstaying means bookended overstaying within 276b5. It isn't the appellant's submission that any bookended overstaying comes within the rule. The dispute between the parties is whether the appellant's circumstances does come within 276b5 or not. And my Lord, just very briefly on the rule, I've made full submissions, and my submissions are in the skeleton as well. The rule must apply to all scenarios. And the difficulty with the discussion around the meaning of the rule and the way one interprets 276b5 A is that the typical scenario is very easy, but the typical scenario is not the only scenario. So typically one would expect that there would be an application within 28 days and that application would be successful. But there will be many cases where that doesn't happen, and Afzal is one of those, in fact, where there was a complication and there was a gap and then there was a further application. And that doesn't mean that the rule doesn't apply as it says it is to apply to those slightly more difficult and exotic cases. It's not a reason to construe the rule differently to what it says. And my Lord, one must look at the rule in the context of its evolution. It has been evolving in a piecemeal manner, and the current version of it came into force at the same time as 39E, and the drafting issues with it are connected with 39E. The difference between A and B is inexplicable, and the reference to the application is, in my submission, likely to be a lifting of that phrase from 39E, and therefore one, in my submission, ought not to read too much into it. One has to look at the overall policy of the rule. And again, as I said in my submissions this morning, the way in which the appellant contends the rule should be construed is consistent with the overall policy when one looks at the way temporary admission is dealt with. Looking now at discretion, and I will also come to, and I don't want to labour the point, but I think it is important to come to the concession that was made in Hock, because it does also impact on the exercise of discretion. And my Lords, of course, will be well aware that these are judicial review proceedings, as were the Hock appeals and as was the Afzal appeal. There is a duty of candour on the Secretary of State. And the way in which the concession was put by the Secretary of State before the Court of Appeal in Hock, in my submission, left a lot to be desired because it left a lot of ambiguity. It didn't make the situation clear, if one is to go by the clarification in Afzal and what has been submitted today. And in my submission, if one looks at the full context of the concession that is quoted in Afzal, and if one looks at the judgments in Hock and the way in which the Court of Appeal in Hock understood the concession, there are real difficulties with understanding exactly what the policy and the practice, which apparently is different from the policy, was and is, and that is relevant to the exercise of discretion. As my Lord said, if there is a practice, then why should that practice not benefit every applicant, and why should this appellant not have the benefit of that practice? And if I could take my Lords to the actual skeleton argument.
Yep.
the relevant concession
Yeah.
that was set out in Avzol is at paragraph 20, but the concession begins at 19. That is the context. And I'll leave my lords to read 19 and 20, and the last sentence in 19, the way I read it in my submission, is a clear reference to this being a policy, not a practice that is distinct from the policy.
Yeah, it's a statement of the circumstances in which 276b5 is relevant.
And it's intended to apply when calculating 10 years continuous lawful residence.
Yeah.
By
Then
reference to the policy guidance.
My lord, yes, and then if one looks at 20, one has reference to practice, guidance, practice, without any clear demarcation between what is policy and what is practice. And certainly no reference to this just being a handful of cases where errors have been made. It's a practice. And the way it's read, and I'll come back to what is said in Hock, and I say the way it was understood in Hock was that the practice is the policy. There's no distinction.
Well, yeah, but that's difficult, isn't it? And this is why, as my Lord Justice Dingemans pointed out earlier this morning, precision in public law litigation is just as vital as it is in private law litigation, because otherwise you get into a movable feast and nobody knows what issue they're discussing. So in the present situation, I think it is important to distinguish between guidance and policy on the one hand and practice on the other, because it's one thing to say that the Secretary of State has not followed her own policy or her own guidance, because that's a clear public law objection. But if the objection is not about failure to follow established policy or guidance, but rather that in practice, in other cases, caseworkers have been more generous than the policy required, and that this application has not benefited from such generosity, then the ground of challenge is different. The ground of challenge is not Secretary of State has failed to apply her own policy. Rather, I have a legitimate expectation that I should benefit from the same practice that other people have benefited from. Now, as I've understood your argument in this case, your client's case has been predicated on the former type of objection, not the latter.
Well, my lord, the appellant's case has from the outset been that discretion should be exercised. Now, in exercising discretion, if there is a practice that would benefit him absolutely, that is a relevant matter. And if that relevant matter is not considered...
Where is there any ground raised at any stage of these proceedings of legitimate expectations?
My lord, it's not a legitimate expectation ground. The ground that was raised was that the Secretary of State has not followed... Well, it was against Judge Gleeson's refusal to grant permission. So it was that in refusing to grant permission, Judge Gleeson failed to take account of the policy as conceded in Hock. So the concession was brought in terms of the policy, and that is the policy. We have a explanation today, which is not in the form of a concession, a written concession, that actually what was meant was that there is a handful, we don't know how many cases, that might have been erroneously decided. But when one looks at the text of the concession, and I'll take my lords to Hock and what was understood by, I think Lord Justice Underhill in particular referred to it in his judgment, as to what this meant, the practice and its connection with the policy. As I understood it, Lord Justice Underhill was working on the assumption that the Secretary of State had conceded that the policy was that bookended overstaying within 276b5 would be disregarded, which means it would be counted. And he didn't distinguish between a practice and a policy guidance document.
But that again is mixing up different things with respect. The rule says that book-ended overstaying is to be disregarded in certain circumstances. So if you're within the rule, you don't need guidance and you don't need practice. You simply say, I'm within the rule. End of. But when, by this stage of the argument, we have to assume against you that you're wrong about being within the rule. Because if you're within the rule, you win anyway. Okay?
Yeah.
So we assume for these purposes you're not within the rule. And then the question is, well, what's the ground of challenge? And I can understand a challenge saying, but there is policy guidance that says even if you're not within the rule, you can still exceptionally have indefinite leave to remain. But then it's another thing to say, well, even if you're not within the rule, and even if you're not within the policy guidance, still there's this nebulous practice out there, which means that we should benefit.
Well, my lord, when this claim began, there was no decision from Afzal. And the claimant, or the appellant, has from the outset, one can see from his grounds, and from the pre-action correspondence, relied on the judgment in hoc. And he has relied upon that to say that I should benefit from my book-ended overstaying. And that incorporates in terms of his case, and of course with the moving feast, one has to give the benefit to the appellant, who is a litigant in person, that at the time that he put his case, he understood that there was a concession made. That concession was understood by the court to mean that any book-ended overstaying was going to be disregarded. So it does bring into play the concession before hoc, before the court in hoc, and the way that it was understood by the court in hoc. And what actually
you mentioned you were going to refer to the judgment in hoc. Which passage is that?
This would be paragraph 38, which you
my lord, yes, it is 38. And there, Lord Justice Underhill says in the last two sentences, clearly the Home Office itself thought that element C qualified subparagraph 1A. Miss Giovanetti told us that the terms of the guidance, as one would expect, reflect the approach which the Home Office takes in practice. So Lord Justice Underhill was considering the practice and the guidance as one. There was absolutely no understanding from Lord Justice Underhill, at least, that there was any departure in terms of practice and guidance. And when one looks at paragraph 20 of the skeleton, one can see why, because the paragraph begins with the word practice, then moves on to published guidance, and ends with practice. And there's nothing there that suggests that there is any difference between the two.
And in paragraph 38, Lord Justice Underhill set out the relevant bit which shows the discretion, which we've looked at.
Yes, and shows the part from the policy, yes.
But you either fall within that, or you don't. I mean, it's rather binary.
My lord, yes, in terms of that part of the guidance, but there is discretion beyond that. And I'll come to the guidance and where there is discretion beyond that.
You may well be right, but Hock was addressing this bit because, of course, Hock was against the background of Mass and Ahmed, where it was said, you haven't got there,
yes,
you're never going to get there, and therefore leave.
Yeah.
And that's why it was significant to point out that, in fact, that's not how the Secretary of State was working it.
Yes.
So I'm not sure it takes you very much further than your first submission, which is, if you look at the guidance, I am entitled to point to discretions within it which should have been exercised in my favour.
Yes, but my lord, there is another point, which is that if one is to read paragraph 20 of the concession now very carefully, in the way in which the Secretary of State submits that it should be, so that there is a departure between the guidance and the practice, the language used in terms of the practice is, indeed it appears to have been the practice that where there are such gaps, i.e. periods of overstaying between periods of lawful leave, so not qualifying that by reference to the rule or the policy guidance, the SSHD has been more generous than required by the language of the rules and has included them as counting towards the 10 years lawful residence.
Exactly, I think you're right to emphasise that passage, because that's the passage which was emphasised in AFSAL. And the reason is this, because when one looks at Hoc paragraph 38, which you've drawn our attention helpfully, what that's all about is gaps of no more than 28 days. That's the passage that's quoted from the policy guidance. And what Lord Justice Underhill seems to have understood is that what was done by the Home Office in practice reflected what was in the guidance. That's what he says. But the point that was taken in AFSAL, based on the words you've just quoted, was to say, actually, no, they were going further than you would think on the basis of the passage of guidance quoted in Hoc paragraph 38. And that's where we get into the territory of, well, what's the relevance of that?
Well, my lord, if they are going further, that's the point, that how much further they're going is encapsulated in that section of the paragraph, and it doesn't restrict the nature of the period. It just says any periods of overstaying between periods of lawful leave. It doesn't restrict it by reference to the rule or the guidance.
Well, I don't think that's right, because if one looks at paragraph 20, and the passage that you've emphasised, what is said is, it appears to be in practice that where there are such gaps, and the such gaps, although it's followed by i.e., is obviously a reference back to gaps in lawful residence falling within the exceptions specified in the second part of paragraph 276b5, which is at the top of the page.
My lord, yes, I would point to the i.e.
It's not just any old gap.
Periods. My lord, I take that point. I would emphasise the description of it in particular, i.e., and bearing in mind what would appear the care with which this was conceded, because it wasn't a concession that there is one policy, it was a concession that there is a policy and a practice, but that's not readily apparent and certainly wasn't understood by Lord Justice Underhill after, I think, a full day's argument. So one has to read it very carefully, and I would submit that there is no reason not to focus on the emphasis in that sentence as to what is being disregarded above and beyond the requirements of the rule.
It's all complicated by the fact that at the time of Hoc, no one was really distinguishing between the impact of the disregard on continuity and the impact of the disregard on calculation, i.e. the totting
Yes.
up, if I can put it that way. And so the language of Lord Justice Underhill, when he talks about calculation, is ambivalent. I think it could mean, well, I think it does mean both, because that was the approach that the court was taking in that case, that the disregard worked for both purposes.
Yeah, I think with bookended, Lord Justice Underhill's judgment was that it counted, but obviously that has been set aside by the Court of Appeal's decision in AFSAL, and my lords have my submission on that and the relevance of other considerations. But my lords, I just wanted to draw your lordship's attention to this because it is an important context for this appeal and for the discretion, because there does appear to be a wider discretion that is in play. And then I'd like to take my lords to the application that my lords have already seen very briefly. At page 41 of the supplementary bundle, which is the first page of the application, my lords will see that there is a positive duty, the first subheading, a duty to give all reasons. You must include all your reasons for wanting to stay in the UK on this application. So it isn't possible for an applicant to make multiple applications. And the way in which the immigration system works is that you make an application, that's the most relevant application, and then if there are other matters that you want to be considered, you put that in with that application. You can't make multiple applications at the same time. And my lords have already seen the section in the form.
Well, I'm sorry, I'm a relative novice in this area, but just based on this case alone, I would query whether that's true. Because as we've seen in the present case, your client presently has the benefit of leave to remain to the end of this month on human rights grounds, and yet he's perfectly able to pursue before this court a different application for indefinite leave to remain. The two things are not mutually exclusive.
My lord, what I meant was when you make an application, it's just that application, and then you can dump in whatever you want, and the Secretary of State will deal with it or not. But you can't have multiple applications ongoing at the same time. I think that is
you're certainly right, and if you make a further application for something else, it's an implied revocation
That's right.
of your earlier one, because of course a lot of people who make serial applications don't appreciate that, and then they lose whatever leave they have by making further applications.
Yes, and my lord, there was.
But my lord is right that in this case, the Secretary of State did say, look, it's being dealt with under a different one. Now, you're right that he did ask for Article 8 leave. If it hadn't been addressed at all, that might have been one thing. But is it not lawful to address it by saying, look, you've got leave somewhere else. I appreciate my normal rule is to have all these hoovered up in one thing, but you've got leave somewhere else and you can make that separate application.
Well, my lord, as far as I see it, for the appellant, there is the primary hurdle, which is that was there an obligation on the Secretary of State to exercise discretion? And if there was an obligation to exercise discretion, however that obligation came about, whether that is because the appellant had asked for it, because of what he said in his application form and what he said in his cover letter, or whether that is because the Secretary of State was obliged to do it anyway because that is what policy guidance says she must do. If the appellant can establish that, then the question for the court is whether that discretion has been properly exercised, and whether the court can be satisfied that if it was properly exercised, it is highly likely that the discretion would have been exercised against the appellant. So in relation to the first point, my submission is that when one looks at the application, and also when one looks at the cover letter, and the long list of matters that the appellant is referring to, which are in the nature of discretionary matters, they don't relate to 10 years lawful residence. He's talking about what he has done, his conduct, his family life, the fact that he's purchased a 3-bedroom property, investments, and the fact that he is now expecting a first child with his new partner. These are all matters that are relevant to the exercise of discretion. So in my submission, when one takes the form and the cover letter together, this is an application for ILR on the basis of 10 years long residence, but it is also an application by the appellant for the Secretary of State to exercise discretion if he doesn't come squarely within the parameters of the rules. The second point I would make in terms of discretion is that the policy requires that the Secretary of State exercises discretion. And my learned friend said that there was only one part of the policy that required the exercise of discretion. I would refer my lords to page 9 of the supplementary bundle, which is paragraph 27 of my supplementary skeleton, where I list what the appellant says are numerous instances of discretion existing within the policy guidance itself. Now, the policy guidance is something that is entirely in the gift of the Secretary of State. She issues that policy guidance to her caseworkers, and the guidance is primarily intended to guide caseworkers in applying the rules. If the Secretary of State so wishes, she can also have policy guidance that makes provision for the exercise of discretion. She doesn't have to, but she can. And you'll see from, if I could take my lords back to Hock, just for the reference to a previous case on long residence. It's at paragraph 51, page 34 of the authorities bundle. And that is an old version of the long residence rules and policy guidance that was considered by the Court of Appeal in MD Jamaica in 2010. And there was absolutely no leeway in the rule. It was a strict rule, 10 years continuous lawful residence. You can't have even a single day's gap in the 10-year period. But at the same time, there was policy guidance, what's described as a concession, which allowed for short gaps. And of course, that area of discretion has now increased because the rule itself is more flexible. But when one looks at the policy guidance itself, that policy guidance has a great deal of flexibility within it. Now, I've already made reference this morning to the judgment in Munir, which makes it very clear that policy guidance that provides for any discretion must be flexible, otherwise it's a rule. So it isn't that you must come within the terms of the discretion and the exceptions described in the policy guidance. And my lords will see that the policy guidance is very careful to use the words may when it refers to the exercise of discretion, not the words must, because if one uses the word must, it turns into a rule, and it must form part of the immigration rules and follow the procedure that is required for that. So there is extensive discretion in my submission, and if I could take my lords to the section 155 that my lords were looking at earlier with my learned friend. As my lord pointed out, there is in that section itself discretion to depart from the rule on when gaps are to be disregarded. At 158, the out-of-time application section contains discretion. In my submission, this refers to not previous gaps, but this refers to the requirement in 276b(5), the first part, which is that when you apply, you must not be in breach of immigration laws. Yeah. And this, curiously, still contains the section for applications made before the 24th of November 2016, because there might be legacy applications still not determined. But when this policy was first published, of course, it would have been just after the 24th of November 2016, so there certainly would have been those applications. You then also have the section that begins at 161, which is time awaiting a decision on an application or appeal. And the section that I referred to this morning at the bottom of page 162, which is out-of-time appeals, which is a clear discretion to depart from the rule. And it says at the end of that section, any discretion on this basis will result in a grant outside of the immigration rules. If one then looks at page 164, this is time spent in the UK with the right to reside under the EEA regulations. Under the terms of 276B and 276A, time spent...
Sorry, why are these of any relevance?
My lord, it shows the discretion. So if one goes halfway down the page, policy guidance says, however, you must apply discretion and count time spent with the right to reside under EU law as lawful residence, even though 276B doesn't include that under the rules as lawful residence for the purposes of calculating the 10-year period.
Is he lawfully resident with an EU or EEA national?
No.
So, but I mean, the
point is there's wide discretion.
Well, there is wide discretion in other areas that have absolutely nothing to do with this case.
Well, my lord, the out-of-time appeal section, I say, and I've referred to that in my skeleton, is akin to his circumstances, and that is why I took my lords to the decision in Munir, because if one starts applying the policy guidance as meaning it's only if you come within this that discretion can be applied, one falls into the trap of treating the guidance as a rule. So if there is discretion, it has to be flexible, and his circumstances are akin to that section. Of course, you also have the gaps, previous gaps, which he falls into. His situation is akin to that, although it's far beyond the 28 days. But my lords will see that even there, there is, in the exceptional circumstances, again, which is not an exhaustive list, reference to not having documents that enable you to make an application. And this appellant, again, his circumstances don't fall squarely within the example given in the guidance, had made an application that had not been considered properly. And so he was pursuing that up until the 18th of December when he got a response, and then he made a further application. And you can see from the cover letter for this application for ILR that he talks about that application being a continuation of the application that he had made on the 2nd of September, except with more detail. And my lord, finally, if I could take your lordships to page 180. And this says, under the subheading, refusing indefinite leave, you should normally refuse indefinite leave if the applicant does not meet the requirements of paragraph 276b. Again, suggesting very clearly that it's not that you must refuse. You have to take account of other matters. And then after the 2 bullet points, as applicants in this category will have spent a number of years in the UK, there may be human rights grounds to consider if the applicant does not satisfy the long residence requirements.
But that's what the Secretary of State has done in this case.
My lord, if one looks at the decision, she hasn't. She's simply applied the rules. She hasn't considered the exercise.
As we've established already, your client was granted leave to remain temporarily, admittedly, on human rights grounds.
My lord, that grant of leave was independent of this application. So he already had that leave.
I understand and provisionally accept that. But what I put to you before was, is it not permissible to say, right, of course we would normally consider human rights, but as you've already got leave, we'll leave that and any further applications in that aspect of it. And is that not a valid exercise of discretion? You've asked for discretion to be exercised. Secretary of State says no, because you've already got an extant leave. What's wrong as a matter of public law?
Yes.
We're not the decision makers. We can only interfere if it's illegal. What's wrong as a matter of public law? Why is that an illegal decision? For myself, it sounds perfectly sensible.
My lord, if the decision maker in this case had applied his mind to the issue with the application, which was that gap, the first problem with the decision is that it doesn't identify the issue. It doesn't understand that the only issue for this application is a gap between the 10th of August to the 28th of November. It considers that the gap stretches until August 2017 and starts variably at 29th of October or 1st of November, depending on which paragraph you read. So the decision maker hasn't identified the area within which discretion needs to be exercised. Had the decision maker recognized that you meet all the requirements, but you've got a problem. Your problem is that you've got a gap between the 10th of August and the 28th of November. I've taken account of all the circumstances, including the immigration history, which he sets out in full in his cover letter. So the immigration history that I took you through this morning, he sets that out in his cover letter. And he sets out other factors. And if the decision maker had said, well, I've taken all of that into account, and I've taken account of all the other factors you rely on, but I don't think it's appropriate to exercise discretion in this case for X, Y, and Z reason, it might be that the appellant would have a different claim. It might be that he would have claimed that the exercise of discretion was irrational. It might be that he would say that you've not taken account of all factors you should have taken into account. I cannot predict what the claim would be, but the difficulty for the appellant here is that there's just been no application of the Secretary of State's mind to the discretion that should have been exercised. And in
Are you
those
maintaining the claim in the ground of appeal that there's only one possible answer to the question? Had the SSHD applied her mind to that? Or
My
are
Lord,
you-
that was in the context at the time that it was agreed between all parties that this was bookended overstaying.
Yeah.
So if it is bookended overstaying, if my Lords are with the appellant on his construction of 276b5, then yes, and I don't.
Then
think
you're
that-
within the rule, so you don't
Yes.
need discretion.
That's right. So I don't think my learned friend would disagree with that.
No,
But if we're in the area of discretion, then it might well be, my Lord, that if discretion was exercised against him, that is the submission that the appellant would make. But he doesn't need to make that submission at the moment because he can submit that there simply hasn't been an exercise of discretion.
Well, that's the
This-
way I've understood your argument to go, but I think the ground of appeal, which I had in mind, if I can find it, was somewhat more ambitious. And it was... here we are. Page 12. Even if the appellant was not able to succeed under the provisions of 276b, his application should have been granted under the policy guidance per the concession made to the court in Hock.
Yes, and my Lord, I maintain that if it is bookended leave, because the appellant doesn't need that bookended leave to count. He just needs it to be ignored, because he has enough leave before and after to make up the 10-year period.
Yeah,
So on that basis, I understand it.
yeah, and what you're now arguing is your fallback position in response to the stance adopted by the Secretary of State in the respondent skeleton argument.
My Lord, yes.
Because that, you say, gives rise to a new question, which is, well, what if it's not bookended overstaying? And in those circumstances, where you say you say that's not correct as a matter of law, but if it is correct, your fallback position is, well, in that event, there's been simply no exercise of discretion.
My Lord, yes. And my Lord, this isn't, in my submission, a case that is suitable for the exercise of discretion on the basis that it is highly likely that the decision would have been the same. Because on the basis of the decision and the lack of anything thereafter that considers discretion in its true sense, in the way that the policy guidance enables a caseworker to consider it, it cannot be said that that is the highly likely outcome. In fact, I would submit that there are passages in the policy guidance, in particular the out of time appeals section, that suggest that actually there is a good likelihood that discretion would be exercised in his favour, particularly because of the temporary admission, the failure to grant that earlier, and all the other factors relating to his conduct during that period. My Lords, I've taken up quite a bit of time in reply, unless there is anything further that I can assist you with.
Well, I think either you or Mr. Keith had promised to tell us what Code 1 meant on this. Relates to your discretion.
Yes.
On page 145, it was to grant them 6 months Code 1 outside the immigration rules.
I don't have any.
I do have a response. I got a response as I sat down. If that was it. So the Code 1 means the grant of limited leave to enter or remain under the rules. That is a grant where the individual can work but has no access to public funds.
So it's a restricted grant of leave to remain for a 6 month period.
Yes.
Yeah. Okay. Thank you.
Very good. Well, thank you both for your submissions, which we will give consideration to and hand down our judgments in due course. The judgments will be handed down in the usual way, that is to say, in writing, in draft to begin with. The draft will be under embargo, and I hope everybody in court understands the seriousness and significance of the embargo. It is to be strictly observed, and it's a contempt of court if it isn't. The purpose of that exercise, as I'm sure you all know, is for you to correct typographical errors and obvious factual mistakes such as transpositions of names and things of that sort, but not to re-argue the case. The other purpose of it is hopefully to enable you to agree between yourselves a consequential order, which we can make at the same time as handing down the judgments. If you can't agree the consequential order, then please put written submissions in briefly on any points that remain in dispute. Thank you very much.
All rise.